Hey everyone, Harry here to talk about a Supreme Court opinion that just came down that is huge. I mean huge. A little hard to talk about because it's more legal and technical, but in terms of impact on everyday life, in terms of sort of revolution in legal doctrine and well-accepted canonical status, it is enormous. Okay, the case is Loper Bright, and what the court did in the case was overrule the Chevron Doctrine. The Chevron Doctrine says that where an agency interprets a statute and it makes a reasonable interpretation of something that's ambiguous, courts have to let it stand. That was ushered in the Chevron opinion in the Chevron Doctrine, and I think a unanimous decision by John Paul Stevens 40 years ago or more in the I think late 70s, and it immediately assumed a total fundamental article of faith within the judiciary. It was much beloved and endorsed by conservatives at the time, who possibly were reacting to worries about too much power otherwise in Congress. But it has been pivotal in decision after decision after decision, including cases that were brought and not brought in anything that agencies do. Medical things, clean water. I'll just read from Justice Kagan, who is the administrative law expert on the court, who says today that it's become part of the warp and woof of modern government, supporting regulatory efforts of all kinds, to name a few: keeping air and water clean, food and drugs safe, and financial markets honest. All of that is completely accurate, and the question that courts have had to date for the last 40 years, including times of real sort of technical growth and complexity of the modern state, media, everything has been, was the agency's interpretation reasonable? There's a recognition that even though agencies are a step removed from political accountability, they have expertise without which you cannot make wise decisions in government. And the underpinnings, the foundation of Chevron is a recognition, and it's been affirmed since then, that this is how Congress wants to handle these things. Congress, our elected representatives, wants to say, we need agency expertise here. We can't write the perfect statute, particularly with all the sort of back and forth of the political process. It's true that it means that there are instances where, Congress isn't sort of putting its foot down and making the hard political choice, but it's usually a hard technical choice. They don't know. They welcome the intervention by agencies and that's what agencies are doing there for their expertise. But notice what has happened here, and it is really of a piece with the most self-aggrandizing and aggressive moves of this new uber conservative courts. Congress says, hey, please, we want you to defer to agencies. That's our take as the country's elected representatives. And today the court says, we don't care. Where things are somewhat ambiguous, that's our job. We're the ones who interpret statutes. And if it's a 51-49, that's for us to decide. Now, how they're going to decide it, in terms of the whole questions this opens up, it's going to be playing out for years. Courts get records of, briefs from litigants, who each of whom makes the most sort of slanted argument, presumably in good faith, that they can, and these judges have to figure it out. So, and think about it. When I say judges, that could be Eileen Cannon, that could be Matt Kaczmarek, who was on the terrible opinion in the mifepristone case. What has happened here, make no mistake, is a huge transfer of power, a tsunami-like transfer of power from Congress / the agencies to the courts, who henceforth will need to decide questions that Congress, which, by the way, can take fact-finding, listen to people, hear, from be politically accountable to lobbyists, but also to the people, and can keep getting more and more information. That's what courts can't do. They just get these briefs. And why they think they're going to be better to decide. I mean, part of this is a kind of very superficial notion of what courts do when they interpret, or they're saying every question is just an interpretation of a statute, as if you were deciding something courts are expert at, whether this comma means that the words that follow should be part of the first phrase or part of the second. That's court business. But as Kagan points out, and it's not just persuasively, it's just accurate. The business of so many important decisions in government have been to the agency's subject. I mean, it's not impossible to overrule an agency decision by saying it was unreasonable. But man, the difference between doing it straight up and having deference to really listen to and try to apply the expertise of agencies is night and day. Chevron, now it's arguable when you look at the initial opinion that Chevron more or less institutionalized the practice as it was already, or maybe not. Maybe it ushered in a whole revolution that completely transformed how we review administrative regulations, which apply the laws, and in many ways are really where the rubber hits the road in government. But after Chevron, that certainly was the case, and man, in a swipe of the court's big scythe, it is gone, and it is really trying to just sort of be in the middle of this field and figure out what this means going forward. The cases that will just be decided for whatever reason. It's not, in the Supreme Court, Elena Kagan is the administrative law expert, and at least there are 9 people there. People can look to Kagan. You have Matthew Kaczmarek, who ruled that the FDA didn't have authority to make these changes in the mifepristone matter, even though the FDA had found in its expertise that it was safe, and they, of course, were right. Now it'll just be him, and of course he can be. This plays into the problem of forum shopping and trying to get the most favorable judge, and that's the person who can henceforth decide. Yes, it's subject to Court of Appeal and potentially Supreme Court review, but the whole regime is completely cut adrift from its governing assumption of agency expertise, and the governing assumption below that, which is Congress, the electorally responsive branch, as opposed to the courts, wants agencies to have the benefit of agency expertise in applying their laws. And just taking a step back, as if you were deciding things as they say, sort of behind the veil, not knowing how things would come out, why you would provide or hand over these kinds of technical, very far-reaching decisions. How many parts per billion of a contaminant, make something according to the EPA, an environmental danger. I mean, all kinds of things that Aileen Cannon, what's she supposed to do? why you would want courts to do this and not agencies subject to the potential oversight of and the endorsement of Congress, is a head scratcher. So it's not simply that it's a revolution by the court, but it's a revolution that really could make government so much less responsive and competent. I mean, we'll see how things play out, but I have one poster child for you, Matthew Kaczmarek, who was eventually slapped down right away because he didn't think about the scientific facts on the ground and just kind of had his statutory interpretation, and that might possibly have been a little influenced by, say, his political views. I mean, it makes the role of not just the Supreme Court, but judges, especially district court judges, all up and down the system, so immensely powerful. And these are the kinds of decisions, some of their other cases, they're huge and they go to who we are as a society, so it matters. But there's in particular areas, I can't emphasize enough how cross-cutting this is. It's exactly as cross-cutting as the role of agencies in our life is broad. I can imagine lamenting that fact and wishing for a simpler life where there was less need for technical expertise. But that's not our life, and not because of Chevron, but because of the growth of technical questions and and all the things that government now has to do. And for going forward now, the interpretation of those all important regulations will be in the hands of individual federal courts with no particular expertise, as opposed to where Congress wanted it to be. And, for law students heads are turning 360 degrees this morning, but it's Chevron. It's not, it comes across as kind of legal and nerdy, but it is anything but. It is as practical and important for people's everyday lives as any legal doctrine out there. I'm maybe waxing a little hyperbolic, but I can't think of any that's bigger. And again, so that's point one, is how huge it is, and point two is that what's happened in effect is power has been shifted from either Congress or the agencies, depending how you think about it, to courts. That is quite a legacy now of this new uber conservative majority, and it's going to be playing out unless somehow this changes for years to come. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.